Hi, I'm Rich Booker, and welcome to The Rich Booker Show, real local news and political talk on Radnor Studio 21. But first, my political perspective. It is often asserted that the world has made a great deal of progress since the founding of our country in the 18th century, and therefore we in the 21st century may discard their conclusions for something more modern. But that reasoning is flawed. The principles of natural law which underpin the Constitution are immutable. In Philadelphia, speaking on the Declaration of Independence in 1926, President Coolidge said, "If all men are created equal, that is final. If they are endowed with inalienable rights, that is final. If governments derive their just powers from the consent of the governed, that is final. No advance, no progress can be made beyond these propositions. If anyone wishes to deny their truth or their soundness, the only direction in which he can proceed historically is not forward, but backward toward the time when there was no equality, no rights of the individual, no rule of the people. Those who wish to proceed in that direction cannot lay claim to progress. They are reactionary. Their ideas are not more modern, but more ancient than those of the Revolutionary Fathers." Just this past week, the Radnor Township Board of Commissioners was asked to approve a resolution that would require our local government to commit to a decade-long contract and acquiesce to the dictates of a national elitist movement designed to rescue the world from the ravages of a warmer climate. These high-pressure tactics, intended to marginally slow climate change by ending any production or use of historic energy sources, will leave all of those who rely on those industries for jobs and income destitute, will infringe on our individual liberty and curtail our inalienable rights. Moreover, this would reduce political accountability to the electorate. To subject our government in Radnor to a contract that would remain in place for decades, no matter what circumstances arise, no matter what the cost, so as to worship at the altar of a new religion of climate change, is not progress. These 100% wind power, plastic straw ban types of ideas are not progressive. They are reactionary. They take us back to a time more ancient, when there were no rights of the individual and no rule of the people. And that's my political perspective for January 30th, 2019. Today, I have with me Mr. Baron Gemmer. Baron Gemmer is a well-known Radnor resident and a citizen expert on land development issues in Radnor Township. Baron is a longtime resident of Radnor and originally from the Midwest. And he's been very involved in Radnor politics for years. And he regularly makes comments at the Board of Commissioners meetings on nearly every land development project. He attends every meeting and is a great aid to those of us in Radnor who are trying to sort through many difficult issues. He's married to his wife Lydia and lives in Radnor's 3rd Ward. So Baron, please tell the audience about how you became interested in local politics and why it's important to you to participate.
Well, thank you for having me, Rich. I think like a lot of residents, you become aware of your government when things in your immediate neighborhood start to happen that potentially could be detrimental to your quality of life,
right.
Or at least want to know what's going on.
Mm-hmm.
And back in the mid-2000s, there were 3 that were going on in close proximity to me. The first was the Wicklow development, which is at the corner of Conestoga and West Wayne Avenue. And then one around the corner of that at the 200 block of Bloomingdale Avenue, there's a proposed subdivision there. And then another one at 400 South Wayne, which I believe we'll be speaking about a little later
right.
too. So it was those projects where I was involved to varying degrees that got me not only interested in what's going on in the government, but what's the process and what are the rules that have to be followed for these to go in so that people can't do whatever they want and that residents aren't adversely impacted unfairly.
So what were your concerns when you say the first development you heard about it, and why was it of a concern to you? Was it because you said quality of life, but what were the issues you were thinking of?
Well, a lot of it sometimes has to do with the height of a building, depending how close it is, and particularly with Wicklow, that's a familiar one to a lot of residents, where they actually built they built kind of a mound a little to put the houses up, so they were starting at a higher point. And if you're in a nearby house, that's looming over you because a lot of those houses aren't that big.
Right.
Like a lot of folks, although it wasn't as prevalent back then, you're always worried about stormwater runoff and making sure that the stormwater is being taken care of. And you're also worried about the density because you've got, another, in the case of Wicklow, another curb cut with, 5 or 6 residents coming out there onto a somewhat narrow street as West Wayne is already. So that's a good example at Wicklow about some of the things that are concerning when you're looking at a development.
Right, right. So you talked about one of the developments that's nearby is Bloomingdale Avenue. Now, for our audience, Bloomingdale is actually the oldest developed area in Wayne after Luella. Then there's some houses on Bloomingdale, which are from the 1870s, which is really the oldest part of Wayne. And there's a couple of developments there. The development that I'm thinking of is not the 200 block, it's the original development where they have the 5 houses. Mm-hmm. So was your concern with that one the density, historic preservation, or what was the issue with that one that's really built right now? And what's the status of that? Because I haven't seen anybody really living there or the houses for sale. Mm-hmm.
Yeah, a lot of people have those same questions in terms of what's going on with that one. A lot of what you said, yes, were the concerns. There was some historic, certainly concern about that. The house that was there, although it should have been on the historic registry for the township at least, because it was built in the early 1900s, was not one of the Second Empire Victorians that you typically see along Bloomingdale, that first block of Bloomingdale. Mm-hmm. So unfortunately, that was kind of a foregone conclusion. There wasn't much to be able to be done about that in the time frame, given what the Harb ordinance was. Certainly concerned about density. Now, in favor to the developer, technically there were 2 commercial properties, very low in use commercial properties. One was an art gallery, the other was eye doctor, and then had various other medical type uses over the years. But having that block go back to residential was a plus, because that is what it's zoned. It's zoned R5, which is why you see the R5 density there. So the concerns then, if it's residential, is what's the density, how is it going to impact our house that we lived in from 93 to 2002 is right on the corner of Bloomingdale and West Wayne, so it abuts the property there. So the concern was, well, is there going to be headlights coming through with their parking and those kind of issues?
Right.
So we actually saw there was some relief that the developer needed. The developer didn't know it at the time, but I informed him, and that's how we...
And he admitted it.
Well, he didn't necessarily want to, but we ended up with not a settlement agreement because it wasn't a court case, but in terms of supporting what he needed, for example, relief at the zoning hearing board, we got some relief that we wanted in terms of buffer and fencing and some other things. So that was an amicable agreement. It's a matter of following through with it. At this point, you asked about the current status of it. From a neighbor standpoint, we have our buffer in and the fencing in, so we're good in terms of being buffered from whatever would happen there. Right now, the houses there are really shells. 5 of the 6 houses. The original art gallery was bought from the developer by a different entity and is being renovated actively. So that may be nearing completion, but it's all part of the same subdivision.
Right.
The other 5, which are the 3 townhomes in back and the 2 single families in front, by and large are just while they're airtight, they're basically just studs inside, and the developer has run into monetary problems and has some judgments looking at the Delaware County court cases. So I don't know how that's going to resolve itself in terms of if the bank will have to take them over and get a builder, or the builder will still be able to work something out. So right now it's kind of in limbo, and that same builder has other developments that have gone on in the township, the one at Stratford Avenue, and then also the one by the Charrington property, which were some single-family homes.
I haven't heard anything from the neighbors in complaints about those buildings at this point. Is the neighborhood upset that nobody's moved in there and they're just shells sitting, or is it a concern, or is it not a concern for the neighborhood right now?
No, that's a good. When I do talk to the neighbors about it, it kind of cut both ways. Obviously, they're happy that it's the state it's in, at least right now, and there's not construction going on. I don't know if you're aware that they ran into tons of stone in the ground, and they had to jackhammer for months.
Oh, yeah.
They were actually living back over there at the time.
Yeah.
So That's the plus side. It's the buffer's in, the houses are up. There's not construction going on the outside. On the negative, yes, you worry about a vacant home or vacant homes in this
Right.
case. What could happen to them if they're going to fall in disrepair because of just age over time without being maintained, or what's going on. So it's a little of both. But
Well,
most of the infrastructure right now is leased in terms of the driveways and the sidewalks. That took a long time to get, even when the houses were up. So we're glad to see that in.
so if there are any problems, let me know. And the Board of Commissioners, I haven't heard of any problems, but we certainly wouldn't want squatters, or we wouldn't want issues going on with that. So I'll follow up on that and see where we are, and if there's anything we can do with the township. With Bloomingdale, you were part of a settlement agreement for the Bloomingdale court development. What did the settlement agreement cover, and why was it needed?
Well, that again was one of the original things that got me involved in local government in the land development process. So the original developer that came in there was looking to tear down two of the historic homes there, which is in the second 100 block of Bloomingdale. Mm-hmm. And just to give you perspective, that first 100 block, as you alluded to, was built in 1870s to 1880s. Some of them started in 1865. That was the first developed residential street in Wayne after, as you said, Llewellyn and the common infrastructure.
Right.
Then there were some hard times, and so then the second block, you see a second Empire Victorian starting there. And then there's other Victorians, but they were built later on. Still part of the historic district, still part of the historic fabric of that. The developer wanted to come in and tear those two down and build 5 homes on where there were those 3, using I'll term an alley. It's called Owens Alley. It really could be a continuation of Owens Lane, which is a road that runs back there, in order to have the frontage necessary to do that. That development had problems with some of the setbacks and some steep slopes and some other issues, and that's what I and a couple of the other neighbors relatively nearby had taken that case to appeal based upon the Board of Commissioners approving that.
And you took that to the Commonwealth Court?
Took that to Delaware County.
Delaware County.
Yeah, it was just from the Board of
Court of Common Pleas.
Yep.
And you ended up with a settlement agreement with the developer. Was that a negotiated, or was that by the court?
No, actually, it wasn't with the developer, because with the developer, I'm not sure what was going on with the developer, if he was having money problems or didn't want to pursue it because he maybe saw the merits of the case. I don't know. Mm-hmm. He ended up selling his rights to another builder/developer. And that's who I negotiated with and got the settlement with on behalf of myself and all the neighbors. And instead of the 5 houses, what the settlement agreement calls for is, of the 2 houses, that one would be allowed to be taken down. It was a minimum of 5 years after the settlement, which we've now reached because that was a while ago. Mm-hmm. The other one would have to be maintained for at least 10 years, and there'd be no right to demo that. That would have to go through the HARB and everything again. Mm-hmm. And obviously, if it's being fixed up, that's a deterrent for someone to throw money away. And then the right to build. So if they tore that one down, to build 3 new houses. So there'd be a total of 4, where there's 2 now,
right.
And one of them would be taken down, unfortunately, for historic purpose. That's kind of the compromise we reached in order to at least save one for a relatively indefinite period, and keep the density down.
So this has been, as recent as this summer, there was still some controversy over this. So is it resolved right now, or are they well on the way to completing that plan that you agreed to, or there were still some issues, isn't there?
There's some issues in terms of when the developer. Part of the settlement agreement was I was to receive plans as they were submitted to the township in Delaware County.
Right.
Some of them, like the sewer modules, I didn't get, which is unfortunate because that turns out to be some of the problems that we see today. When they submitted plans saying they were going to go ahead, there was all throughout it talked about demolishing that second historic building, which we talked about was preserved.
Right.
And they were also basing their sewer units based upon that, because that's a 3-unit apartment building and was going to stay that way. And in all the documentation submitting to the township, it was in the county, it was going to be a single-family home, which obviously has different sewer needs.
Right.
And the like.
Basically 1/3.
So what was submitted to the township, I had to point that out to the township. The township asked me to talk to the developer. I said, well, this is your job to review this. It's a tri-party agreement.
Right.
The township signed it, the neighbors signed it, and the developer who took over signed it.
Township just said, answer Mr. Gemmer's questions, please, Mr.
Yes.
Developer.
Now the engineer answered first, and he obviously hadn't read the agreement because he was coming back with, this is what we're allowed to do, and I was like, no, read the agreement. And finally, the developer who I had made the settlement agreement with chimed in. He said, no, you're right. This is wrong. We submitted wrong information. So in terms of where that is, it depends because I'm not sure what the sewer module situation is now because it has an incorrect number of sewer modules.
I think that's opened up. That's loosened up since then.
Yeah, well, they would still have to go through the process to get those.
Yeah.
You see the perfunctory approvals at Planning Commission and Board of Commissioners.
Right.
Excuse me for those, and they haven't gone through that again. So that may open up, and they may very well be able to proceed with development. And I am wholeheartedly in support of that. I mean, that's why we do the settlement agreement. We came to a compromise. If the developer wants to execute that, that's his right, and that's our agreement.
Is there anything that the Board of Commissioners needs to be aware of with respect to that settlement agreement and this development as it proceeds at this point?
Just in terms of that there needs to be resubmissions of some of the documentation that was sent to Delaware County as well as the township, both in terms of the sewer modules as well as some of the others to make sure everything is consistent with the actual agreement and what the subdivisions be. And actually that's a issue too with the other Bloomingdale development, strangely enough, going on.
Resubmissions.
Yeah.
So one of the most famous cases that we have in Radnor was one of your another one of your projects you worked on and were heavily involved with, and that's the 400 South Wayne LP development, and that really you made some very significant legal precedents on the issue of steep slopes. Can you talk a little bit about the 400 South Wayne project and what's currently going on with that project as well? Because I think that's still underway to a certain extent.
Yes, that actually requires more attention. Let me give you and the viewers a little more background too on that. As I mentioned before, back in the mid-2000s, that was one of the
It's like 10 years ago.
It started more than that. I think the decision by the court was like 2007. So
Right.
we're talking probably 14 years ago that it actually started in earnest with the developer. And I don't want to take full credit for that. Whereas on the Bloomingdale one, I was on the suit and leading that up.
Right.
Wicklow more in the background. On this one, I was helped. I was not part of the suit because I got to the group too late, but I did assist them after that. So instead, in the mid-2000s, a developer came along and bought that property. I'm not sure when it was equitably owned versus actually owned, but that's one of the mistakes that occurred during this from the developer standpoint.
Right.
Tried to put in a subdivision plan, not unlike the one Bloomingdale project I mentioned, had problems with setbacks because it's a corner lot, and those are more issues,
Right.
as well as much more steep slopes. If you're obviously familiar with the township, South Wayne starts up high at Conestoga and goes down, and
Right.
so there's many slopes on that particular property. So it went before the Planning Commission. The Planning Commission voted to turn it down, and so did the Board of Commissioners. But unfortunately, administratively, the denial was never sent out to the developer. And as you're aware, that becomes a deemed approval if the developer is not notified of that. And so the neighbors then found out about this. And so the neighbors tried to get involved. This was just as a little level set here. This was part of the prior administration and prior solicitor, prior township manager, et cetera.
So it was Bayshore and Blake.
Exactly, Bayshore and Blake, who weren't really giving us a lot of help, like, oh yes, I'm sorry we made that mistake. So it was really the onus was on neighbors. We had to really push them to just get out of our way so we could take it over.
Right.
And so we went to Court of Common Pleas in Delaware County, appealing that deemed approval based upon the steep slopes and the setbacks, and won a reversal of that deemed approval based upon those items. And as you mentioned, the steep slopes moved forward to a lot of other things. But then let me move forward here now. That property has been sitting with that home in various states of disrepair throughout the years. Lately, it's been decently, I don't want to say decently, but it's been reasonably kept up, so it's not, with broken windows and things. So another developer is working with the developer who bought that. And again, part of the problem with the developer that bought it, he didn't buy it equitably, so now he owned it and had to sit on it. He couldn't just let somebody else buy it for a single-family home in and of itself. So another developer came along to offer to build with this other developer, and although he only wants to build a single-family home, the way the zoning is written for that with the steep slopes is when you have a lot that is that big that could be subdivided and there's steep slopes on it, any kind of man-made change, i.e. Building on it, demolishing it, the building, has to go through a subdivision process. And that's what right now that the township is, originally John Rice made that determination, which is not appropriate under the MPC, Municipalities Planning Code of Pennsylvania, which governs the land development here. And now Kevin Kachansky, the zoning officer, has weighed in, and I gave him some facts, asking him to reconsider, but I may end up at the zoning hearing board again on that. So that's where that development.
So it sounds like, again, that one's not being developed either, and it's problematic. It's not finished, and
well, it never got started. Basically the abandoned home that was there probably from 2000 is still there.
Still there, almost 20 years later.
Yeah, which from some perspective, because of we part of the reason we're pushing to make sure this goes through this land development process is in looking at what would be developed there. It would be very much out of character with the neighborhood. It would disturb steep slopes, which is obviously an issue of process. But so to the extent we can, just like with the Bloomingdale's one, we're seeing if we can do a compromise to make
work out a
happy.
settlement.
I'm not sure that's going to be the case. It might just have to go through the regular process, which would be perfectly fine with.
Is that something that will be before the board anytime soon? I haven't heard anything about it other than an email that we saw Kevin was talking to you about recently.
No, not unless the township would get involved in the zoning hearing decision, which I don't think in this case they would, because until I'm not sure the developer wants to submit a subdivision plan. They would rather just build the home. But if subdivision and land development is what required under the zoning code, then they would have to do that if they wanted to proceed. So you'll see it when it gets to that point. Right now, there's still the arguments being made about this is what the code says, this is what they need to do, etc. And again, if I get a decision that is adverse to my opinion based upon that, then I will proceed to the zoning hearing board and let them adjudicate that then.
So still a long way. Another really controversial development that we have pending at this time is Maplewood, a new development off of Maplewood Road. And that one has a plan for a very long driveway that they don't call a street, a long driveway and 10 townhomes. And that was denied by I don't know if it came to the board, but it has been denied. It came to the board and we denied it as well. That project, as I said, uses a long driveway and they don't want to call it a road. What's your opinion on whether something like that should be a road or a driveway? And it makes a difference on how they develop.
Yeah, and actually that kind of determination cuts both ways for both the township and the developer. And there's SALDO, which is the Subdivision Land Development Code, which talks about a driveway not serving more than like 3 homes. So
this serves 10.
This one serves 10. So you need waivers for that. So the board, that's one of the reasons the board could deny it, because they say, look, that's too long. In terms of what to call it, to me, something that long should be a road, which would require then a cul-de-sac at the end, if that's the way it's going to be. The township is kind of treating it both ways in terms of the characteristics of the road, even though it's a driveway, because a driveway does count against the developer as far as impervious, because there's no right of way. That's part of their property, or part of their non right of way property. So that would be one thing again, but the code would push them toward a road because of the waivers they require upon the number of houses being served. So I would want to see it either go one way or the other.
The road would not count towards their impervious.
The road would not count, but then there'd have to be setbacks.
But they don't have the setbacks.
Yeah. Well, they could probably finagle it if they were doing, but they're also trying to do a different kind of development in R5, which is the multifamily development versus like the individual lot development.
Right.
That's the same thing that's gone on. Not at the 200 block of Bloomingdale is actually individual lots with a shared driveway, even though they all have street access. The 100 block of Bloomingdale is your typical multifamily development under R5, the residential 5 district, as was Wicklow. So that's the problem. It's one big piece of land, so putting the road through it, that makes the setbacks tougher. If they were to individually parcel it and make that a road, they'd lose some things and they'd gain some things. One of the things they would gain about the road is the impervious, because the road would be in the right of way by definition and wouldn't count against their impervious coverage.
So also with that Maplewood project, there was an old roadway which was abandoned, I think, and there's a quitclaim. But there's still an issue on access, and there was an old access way that's part of that, which was not part of that abandonment, as I understand it. Can you briefly talk about what that issue is that's still outstanding, and is it important enough for the township to really be aware of?
Yeah, well, I mean, both the current denied subdivision, which is up at Delaware County, as well as the original quiet title, which I'll get into. I think both of those are causes for concern and need to be looked at. Going back to the quiet title, there's a road that on paper that ran through that entire development. It bordered the trail and then came back, from Highland over to Maplewood, basically.
Right.
And it was the way the deeds were written is no one actually owned the road, but they all had rights to it the way the deeds were written. There's some question about some of the deeds, trying to find the prior versions of them where that was, but that they all had access to that in ingress and egress to their property. And just as a way of contrasting that with the current development, the current road does not follow that path. They kind of just merged the properties together and did that. So back to the quiet title. The issue with there's several issues with the quiet title. The first issue with the quiet title is that it was a real estate matter. It was a legal agreement, but it was never authorized by the Board of Commissioners, it was basically signed and settled improperly. So that's issue number one. Issue number two is because the road was not owned by those properties. Normally in the township, your property extends to the middle of the road and there's an easement there for the right-of-way. That's not the way these deeds were written. The road was an entity unto itself. So
it was dedicated to the township.
No, it wasn't dedicated to the township. That's why it was basically not dedicated at all, but it was there were rights there, but it was unclear as to the ownership.
Ownership of the dirt there.
But it wasn't owned by the abutting properties, which is normally the case. So the issue was in the quiet title, the settlement said that each of the properties is going to own to the middle of that, and basically then they were going to mush it all together. But the problem with that is that's a change in property lines, and by definition, that's a subdivision. So not only was the settlement done improperly because it was never approved by the Board of Commissioners, even if it had gone that route, it would need to have gone through the subdivision route because it involved all these properties changing all their lot lines. So that's underpinning this second development, which was turned down. So there's problems with the foundation that even allowed to get to this stage.
Well, so in this final minute that we have, what do you think the commissioner should do with this Maplewood development? Should we try to work something out with them, or is this really just too far gone that we should try to rethink the whole thing and maybe scrap the plans?
Well, I think in fairness to some of the neighbors who I've talked to and tried to help along the ways, they still have an issue with that underlying quiet title because they had access to the trail, which they no longer have, and any kind of settlement really, that whether it's 8 or 10 homes, is invariably going to run into zoning issues, which can become somewhat brushed under the rug in a settlement agreement, but that's not fair to the neighbors. So the township really needs to take a step back and rethink this from scratch, because otherwise they're not going to have the choice of this. The neighbors may step in and re-enter both suits and take away their power anyway in terms of being able to settle.
All right. Well, I appreciate you being on the show, Baron. Obviously a very, very excellent grasp of all these really technical issues in Radnor. And that's all we have time for today. Join me next time when I interview some of my neighbors near the Villanova campus on yet another new controversy that's come up regarding a dome. So thanks again for joining me, Baron.
Thank you.
This has been The Rich Booker Show, real local news and political talk on Radnor Studio 21. Thanks for joining.